Hello, I'm John Miller. Welcome to my website. I'd like to tell you today about discharging debts in bankruptcy. That is, what debts can be discharged and what debts might not be able to be discharged in a normal bankruptcy case. Generally speaking, you can discharge all unsecured obligations or debts like credit cards, medical bills, personal loans. Those are the kind of debts that most people have and expect to and want to get rid of in bankruptcy, and we can certainly do that. Some debts cannot be discharged, like student loans. Unfortunately, we can't discharge student loans in bankruptcy. There is a provision in the bankruptcy code that provides that if you can prove an undue hardship to the court, the court has the power to discharge student loan debt, but unfortunately, the standard, the bar set by the courts for proving undue hardship is so high that, frankly, student loans are, as a practical matter, simply non-dischargeable. It's also true that child support, alimony, and other obligations, property settlement obligations, and a divorce decree are not dischargeable in a Chapter 7 bankruptcy case. Now, a property settlement ordered in a divorce decree can be discharged in a Chapter 13 repayment plan. So if that is your main problem, being ordered in a property settlement payment in a divorce decree, we can look at a Chapter 13 bankruptcy repayment plan to get rid of some or all of that debt. Secured debts are dischargeable in a bankruptcy. Secured debt means the debt has a lien on a house or a car, or you're paying on a house and a car to keep that property, and you can keep house and a car through a bankruptcy. That's what most people do. On the other hand, you can choose to let the property go, like let the car go into repossession or surrender it, and we can get rid of that debt, a repo debt, in a bankruptcy case. Some taxes may be dischargeable. Most taxes probably are not. But some older income taxes may well be dischargeable. I have a different video on my website here that you can find and get more information on the dischargeability of tax debt. Criminal fines, criminal penalties, restitution ordered by the court in a criminal case, we cannot discharge or get rid of in bankruptcy. Liabilities or debts arising from automobile accidents, generally speaking, are dischargeable, whether it's property being destroyed, car damage, or even a personal injury. Whether you had insurance or didn't have insurance on your vehicle, those debts are dischargeable. If, though, the debt was incurred by a drunk driver who is the debtor in a bankruptcy, any personal injury or caused by a drunk driving accident is not dischargeable. There's a category of debts that are also not dischargeable. That is, debts that were incurred by the debtor having committed fraud or misrepresentation, lying, or use of false financial statements in order to incur the debt. If a creditor believes that that's the case, then the creditor would have to, during the bankruptcy case itself, file a complaint and try to prove up that allegation of fraud or misrepresentation. The creditor has 3 months to do that during the bankruptcy case. If they don't file the complaint, then that debt's discharged as well. I probably should let you know that a discharge can also be denied by the court or the trustee who represents the court, either before or after the discharge. Before or during the bankruptcy case, if you're not forthcoming and honest with the trustee in the court, you conceal assets or hide income. That can be a real problem, and if the court or trustee finds out about it, you can be denied a discharge. And if the discharge in your bankruptcy case has already been entered, the court and the trustee can revoke the discharge if, after the bankruptcy is completed, they find out or discover that you hid assets or income or were otherwise dishonest in the bankruptcy filing. So that's a brief review and description of the debts that can and can't be discharged in bankruptcy. I hope that helps you understand some of these ideas. It's especially important that you be completely honest and forthcoming with your attorney, with me, or your attorney, to make sure that the bankruptcy petition filings are all accurate and complete. So if you want me to help you out in looking at your options in bankruptcy, feel free to come in anytime. Give us a call. It's a free visit. So we'll see you then.